Well, in Connecticut, a person is entitled to refuse a blood test. And if the person does refuse a blood test, then the police officer is required to give the person the opportunity to submit to a breath or a urine test. If the person refuses to submit to a breath test, then the person will have lost their opportunity to give their blood alcohol content or get a reading of their blood alcohol content, and the case will be classified as a refusal. And what that means at DMV is it generally means the person will face a license suspension twice as long as they would had they taken the breath test. And it also means that if they'd otherwise be eligible for a work permit if it was their first offense, if they refuse to take a test, they'd have to wait until they serve at least half of their suspension period, which is 6 months, for refusing to take the breath test. At criminal court, it means if you have a trial on DUI, a judge is permitted to instruct the jury that they may draw an unfavorable inference from the person's refusal to submit to a breath test. Basically, why would somebody refuse a breath test if they thought they were not drunk or they thought they would pass it? So every case is different regarding whether or not one should submit to a breath test, but there are consequences for not submitting to a breath test, and generally at DMV you face a longer license suspension and inability to immediately obtain a work permit when you refuse to take a breath test.